All right, good morning. Welcome to this month's Industry 30. Please introduce our speaker today, Andrew MacDonald from Fox Rothschild. He's going to be giving a legal update on changes to non-competes and federal overtime laws. You do have the ability to unmute yourself, so if you have any questions, feel free to unmute yourself and ask your question or use the chat feature. This program is being recorded and will be uploaded on the chapter's website if you'd like to review after. If you have any questions, just let me know. With that being said, I'm going to turn it over to Andrew. Thank you.
Good morning, everyone. Thank you, Rob. Again, I'm Andrew MacDonald. I am a partner at Fox Rothschild in Philadelphia. You may have seen me on one of these updates in the past. What we're going to go over today, and I've promised Rob 30 minutes, no longer. Lawyers tend to go over time. We're going to address two important changes that are possibly coming to the law, employment law, in the next 6 weeks for one of them, and if in September for the other. These are changes that will impact your executives in terms of non-competes. They might impact yourself in terms of the non-compete issues. For federal overtime law, this will mainly be affecting office employees. So your salaried office-based employees, you're not talking about electricians or linemen. This is gonna affect people who are working the office, non-manual labor. And as you'll see pretty soon, there's gonna be some pretty significant changes that are gonna come into effect on July 1st. So only about 6 weeks from now. So as I noted, these are the two very important developments. They were announced in April, and they're going to go into effect pretty quickly. So one is from the Department of Labor. So as you can imagine, the Department of Labor has a lot of say in employment law. The second topic of non-competes is actually an action by the Federal Trade Commission, which is not normal. They do not normally impact employment law, but their action on non-compete agreements obviously touches into the employment world. So let's talk about this Department of Labor regulation. I want to note at the beginning, not at the end, not sneak it in at the end, that there is pending litigation in a Texas federal court that may make it that this regulation does not go into effect. There have been numerous nationwide injunctions issued by federal courts in Texas over administration action, agency action, regulations that have stopped regulations from going into effect. So there is a chance that this rule before July 1st is halted. But that's only 6 weeks away, and there's only a chance that the regulation could be halted. So we think that it's better to plan on implementation. But for those of you here who are in charge of the business, who are in charge of implementing changes, especially legal changes, what I would say is it'd be important to not make any announcements if you are not going to make certain changes, really raises to unemployment, to people who don't now qualify for overtime. If you are going to, not put those in effect if a court blocks this regulation, you want to make sure you're not making promises that you're not going to carry forward. So a little bit of background. Why and how is the Department of Labor able to, with the, snap of its finger, change overtime minimum wage standards? So the Fair Labor Standards Act is the law passed by Congress. It's a New Deal law. It's from the 1930s, and it includes various provisions for the Department of Labor to issue regulations to clarify items in that act. So the Fair Labor Standards Act sets the minimum wage, but as you can imagine, that has been updated since the 1930s. And who did that updating? Not Congress, but the Department of Labor. So the Department of Labor for decades has issued regulations clarifying what is the minimum salary that an employee can have without being required to track their time and be paid for time over 40 hours in a work week. Also, those regulations define what kinds of duties an employee needs to perform to qualify for those exemptions. This regulation only addresses the salary threshold. It does not change the duties test. But the duties are still important. Someone needs to be able to perform these administrative, executive duties that would qualify someone to be a salaried employee in the first place. So there's a duties test. There's also the threshold salary test. So just want to make sure you don't forget about the duties test. There are some people who you may think are administrative, but maybe they don't have the kind of independent judgment and authority to qualify for that kind of exemption. So we're not going to talk about that today, but I just want to flag it because you always have to meet two parts for an employee to be considered an exempt salary employee. So the duties test and then the salary minimums that we're going to talk about in a second. So this is the substance of the regulation. So right now, as it stands, an employee who's exempt has to be paid at least $684 a week. That equals out to about $35,600, $35,598 a year. And what this means is right now, if someone's making $34,000 a year, they cannot be an exempt employee. They have to be paid overtime, even if they perform administrative duties that qualify them for that exemption. Simply because someone works in an office does not mean that they can automatically be a salaried employee. So that number, as of July 1st, is going to jump to $844 per week. And that equals out to $43,888 a year. So if you have someone who's right now making $40,000, they meet the duties test for administrative duties, that person can be treated as a salaried employee. You don't have to track their time, and you don't have to pay them overtime, time and a half, for 40 hours worked in a work week. But as of July 1st, if this rule is not halted by a court, that person would need to either, one, get a raise so that they get that $844 guaranteed per week salary, or you have to start tracking their time and pay them by the hour and for overtime for hours worked over 40 hours in a work week, so 7 days. Now, this regulation, it doesn't just raise it on July 1st. So that's your immediate concern. I think most employers are ready to deal with that. Some people might get raises, some people might be treated as hourly. But look at the next jump. It's only January 1st of next year, 2025. It's not that far from now. It will jump up to $1,128 per week, almost $60,000 per year. There are going to be, if I had to hazard a guess, millions of employees who right now are properly classified as exempt employees. They make $55,000 a year. Come next January 1st, they will have to either be given a raise to over 58,656 or be converted to an hourly employee. And I think that is going to have a tremendous impact on small, medium-sized businesses that have employees, people who work in the office They're probably not making $60,000 a year, $58,000 a year. There are going to be changes that are going to be made, and consequences if you don't. So you could face lawsuits seeking back wages. I also want to note, because there could be some people in this audience here that have an employee who's, quote, highly compensated. So highly compensated employees right now have to be paid $107,432. That's going to raise up to 132 and then 151 January 1st. If you have someone who's a highly compensated employee, this is kind of a hybrid exemption, someone who doesn't quite meet the duties test, but makes this much money anyway. You may have someone in this. Highly compensated employee, I always think should be reviewed by counsel, but this regulation raises that. So just wanted to highlight that for you too. Now, look at the third bullet point here at the bottom. The DOL has said in this new regulation, every 3 years, they're going to raise these amounts that I just talked about. So 3 years from now, that 58,000 could be jumping up to 65. It could be jump up to 70. It could jump up to 75. The DOL has not included these automatic escalator provisions in these regulations in the past. And where they have jumped into that territory now. And so you're going to have to pay attention to this every 3 years if this regulation goes into effect. And so, it's something that you got to look out for. So here are the consequences. So like I said before, you may need to restructure jobs. You may have to adjust your budget. You're going to either have to give someone a raise if they don't meet those thresholds after July 1st or January 1st, or start paying them overtime for their hours worked. And you may discover that someone has been working more than 40 hours. Maybe you thought, oh, she comes to the office, she does her work. Like I bet she's 40 hours a week. Well, when you start tracking that person's time, maybe it's really 45 hours a week. And now you're paying that, you're going to have to pay that person 5 hours of overtime that week. And you have to make a judgment call. Do I convert someone to hourly, or do I give that person a raise? And just remember, if you're planning on that raise strategy, that's going to go up in January, and then it's going to every 3 years escalate up from there. So if you go on the raise strategy, you may end up converting that person to hourly in the future. If you don't make these changes, potential for lawsuits. This would be a wage claim. So I want to highlight two things about lawsuits, because you could think, oh, well, look, if someone sues me and they have 5 hours of overtime, like, what's the big deal? I'll calculate that out. It can't be that much and pay them. Well, depending on what state you're in, most of you are in Pennsylvania. There are liquidated damages. There are double damages under federal law, and attorney's fees. So, and if you have multiple employees, it could be a class action. So now it's really double damages. It's paying for that person's lawyer, paying for your lawyer. And another very important thing that you really should remember, they're not insurable. Wage claims are not covered by your employment insurance. So it's not like a discrimination claim. This would be all out of pocket. You would pay for any liability or settlement, your lawyer and the employee's lawyer. They get very expensive very quickly. And if you have someone say someone is working in, just as an example, Maryland state law is triple damages, not double damages. So then there's another whole level of damages there. So you really got to watch out, and there can be some drastic consequences, even if the real damage to that employee is only minimal. I'm going to hold questions for the end. I'm going to roll through this next bit. All right. So non-compete rule. This is the Federal Trade Commission stepping into the employment world. What they did is they issued a rule in April that said that non-competes. So a non-compete You may have this in your contracts. You may have these in your kind of executive employee contracts. This rule nationwide says that they are now unlawful. They are a unfair trade practice. That's what the Federal Trade Commission oversees, and that a non-compete on a nationwide basis would be unlawful. It is scheduled to go into effect in 120 days from April. It brings it to September 4th. So I want to note again, I underlined it here. This is another administration action that could be enjoined by a Texas federal court. It has not yet been, but there is pending litigation. It could be halted. But again, let's prepare in case it goes into effect. So what does it prohibit? It prohibits new non-competes, but it also prohibits employers from enforcing existing non-competes. It's basically a retroactive rule. It says that all non-competes nationwide, with some limited exceptions that I'll go over in a moment, are unlawful. So if you have a non-compete, if this rule goes into effect September 4th, you do not have a non-compete anymore. If your employees have a non-compete and you're relying on that as part of your business strategy, as of September 4th, unless this is halted, your employees do not have a non-compete anymore. This is a drastic rule. I wanted to share with you a little bit about what the Federal Trade Commission says will happen with this, because they want to tout the positive economic impact of this. So they claim that there'll be more patents, more innovation, people will be able to start their own companies and higher earnings. They believe it will impact 30 million employees. Okay, so we need to split up senior executives and not senior executives. I'm going to tell you in a moment exactly what senior executive means. It is really CEO level, CFO, people who can make policy decisions for the company, not simply someone who is a manager or a supervisor. The FTC estimates that only 1% of workers in America will meet this test of senior executive. So if you have a senior executive, the people who are not senior executives, so it's no new non-competes, no enforcement of existing non-competes, and then you have to inform employees that their non-compete is no longer valid. If someone is a senior executive, you can enforce existing non-competes, but no new ones. So here's that definition here of senior executive. It's someone who makes over $151,000, policy-making position. This term senior executive is an SEC, Securities and Exchange Commission definition, and it really targets high level executives. If you're a small contractor, it may just be you. If you're the owner, it may just be the person who's really in charge and no one else. So it only covers a small percentage of employees. So what you're going to have to do is not just not enforce non-competes, but you're going to have to actually reach out to employees who have non-competes and tell them that they're no longer enforceable. So email, text, hand delivery, mail. We obviously would prefer a letter that is mailed and emailed. We don't want you texting, although you could probably save that. That's something that could get lost in the shuffle. These are some things that we've already gone over a little bit. You can have an existing non-compete with a senior executive. The other main exception here are non-compete clauses as part of sale of business. And in this audience, if you sell your company, you can have a non-compete as part of that sale. So if you sell, or if you're the buyer, you could keep either you, if you're the seller, or if you're the buyer, the company that you're buying, that owner of the company, you can enforce a non-compete against that person, or they can enforce it against you, so you don't start up a competing business after you've sold your business and presumably made a decent amount of money doing that. It's really going to be the main exception. There are, if something is subject to pending litigation, if you are trying to enforce or having a non-compete enforced against you right now, that is exempt. And then one very important thing here is non-solicitation, NDAs, confidentiality. Those types of provisions are not non-competes. So a non-compete is a provision in a contract that says you cannot operate, support, be employed by another entity after you leave that is competing with your prior business. That's a non-compete. You can't compete. Non-solicitation is different. If you just have a non-solicitation agreement, says, hey, after you leave the company, you can't go and solicit our clients for 1 to 2 years. That is not covered by this law. Confidentiality. You have to keep our confidential business information, our finances secret. That's not a non-compete. So those provisions are not covered by the agreement. In an employment contract, you often see these all lumped together in one provision. So say it's, it's section 10, A, B, and C. Section 10A may be the non-compete, but B and C, if it's non-solicitation and confidentiality, those can remain in place. It's just the non-compete that is addressed by this regulation, this rule. Now, the FTC, though, refused to say categorically that a NDA, confidentiality agreement, non-solicitation will never be subject to their rule. What they wrote, and I had to quote it here because I wanted to make sure I didn't misrepresent. They basically said, if you have such a strong, stringent non-solicitation agreement that would prohibit you from ever working in that business, then or for 1, 2, 3 year period of time, that is has the same practical effect as having a non-compete. So if they say, the agreement says you can't solicit any customers in Southeast Pennsylvania in, seeking electrical services, that is essentially the same as a non-compete, and that would be prohibited. But, if it was tailored to say for a year, you can't solicit our actual clients, that would be fine. That's just a plain standard non-solicitation agreement. They're saying is at some point, if the non-solicitation is too broad, it transforms itself into a non-compete agreement. We talked about the sale of business exception. So, you want to make sure that if you are selling your business, or if you are the buyer of a business, that you actually can use non-competes there, because someone in that transaction is presumably getting a decent amount of money. All right, so under a half hour, do we have any questions?
Thank you, Andrew. Yeah, you covered a lot in a short period of time, so thank you for keeping it on track. If anyone has any questions, please feel free to unmute yourself and ask Andrew.
Andrew, I have a question. Ken McDougall.
Hey, Ken.
So the policy making position of 151, right? This is just a hypothetical. But let's say you have a long-term employee who manages the warehouse for an electrical contractor. He starts out of high school. He does a great job. He now runs that part of the business, right? The owner, the president, they rely on him. He makes suggestions. He decides who's going to deliver. He decides when to take equipment to other jobs, to move them around, to schedule the equipment, to add deliveries. Now, he's doing all that. Can he be classified as an executive, or is it just his salary is over? And, he's been there 40 years and he is just, he just through natural growth of the company, he exceeds 151. What is his status?
I would say it's doubtful that he's a senior executive under this rule. What the rule is targeting is people who could decide, are we going to buy a new warehouse? Are we going to have a warehouse? Are we going to subcontract? They have to be able to make policy decisions for the entire business, not just a department. That was actually a specific comment in the rule. And the FTC said, well, just because someone controls a department doesn't mean that they are or aren't a senior executive. Like if they could decide to sell that warehouse on their own, they could be a senior executive. But just because they run a department or a segment of a business, that's not automatically going to make you a senior executive.
Thank you, Andrew. Any other questions?
Rob, I have one. Andrew, Joe McCreesh, great presentation, by the way.
Thank you.
Andrew, I was curious, if we have non-competes and non-solicitations already agreed on and filed, and that they're non-enforceable if this goes through, or at least the non-compete portion of it is it advisable to reconstruct those agreements because they're part of an employment agreement, or just give them the notification that says, according to federal law, the non-compete is not, is against the law and it's not in force? Like, should you redo the agreements, or can we leave the agreements in play and just give the notifications as you noted?
You could leave the agreements in play, just give the notification. What you should do is look usually down near the bottom of an employment agreement, and it will say something like either separability or severability. And what those provisions talk about, it says if any part of this agreement is rendered invalid, they'll say either one of two things. It will say either we'll just enforce the rest of it. So you've kind of already made that bargain. If something is found unenforceable, like this non-compete, then you'll enforce the rest of the agreement. Some of those provisions, though, say something different and say if something is rendered invalid, it doesn't say that you will just follow the rest of the agreement. It say, you'll meet and discuss and possibly change the provision, the agreement. So you may kind of have a bargaining obligation under that kind of provision, but I would check your specific language, because I'd be concerned and someone could bring a complaint with the FTC, or they could try to go to court to say the FTC said these are invalid, and now they're not just taking my non-compete away. Now they're retaliating against me because I had this non-compete, and they're trying to redo my contract. We actually had an agreement, and in it says if something's invalid, we're just going to enforce the rest of it as is. So I think you've got to look at what the specific language in your agreement says.
Awesome, thank you.
Mm-hmm. But when that, if that agreement runs out, everything's fair game. And I would say, say it expires in a year, 2 years. If people are getting their non-competes taken away, that your salary or your employee's salary was in part, at least, based on having that non-compete. And what we're expecting is that employers will try, maybe they won't get it, but to reduce kind of senior people, maybe not senior executives, but senior people, senior employees, try to reduce their pay because now they've lost the non-compete. Will that work? I don't know, but I can see that happening as a trade-off. You no longer have a non-compete. We don't want to pay you as much.
Thank you, Andrew. Any other questions? If hearing none, I really appreciate everyone hopping on this morning. This recording will be placed on the chapter's website. And I hope everybody has a great day, and we'll see you next month. Thank you.
Thank you.
Thank you.
Thanks,